Hi,
Hey, Jen.
how are you?
Hey, I'm doing great. How about you?
Great,
Good,
great.
good.
It's even better today.
What's that?
We have Brian Sutter here with us
Hello,
from
everybody.
Sugarman.
Hey, special guest Brian Sutter.
Happy to be here.
I was going to say our special guest today is Lagavulin, but
Oh, no, talk
it's-
about that too.
But Brian's here also. I forget about
that. I'll take second fiddle to that.
that. So we're here for another whiskey tips with Jen and Eric. And yeah, we have our special guest. We're excited to have Brian here. We're going to talk about the claims process today. But before we get to that, because it's whiskey tips, move my camera down and see if we can pan in here on these delightful treats I have in front of me. Obviously more than just whiskey, right? What do we have? We've got a couple Lagavulins.
Got a couple, when one's just not enough.
We've got the 8-year option. We've got the 11-year special edition here. This is the Offerman edition. For anybody who doesn't know, Nick Offerman is a Lagavulin fan, has become the spokesman for it, I guess. So he's got a special edition that's finished in Guinness casks, which is also why we have the Guinness here today. So we're kind of running the gamut. Lagavulin is a Scotch whiskey from, what is it? The Isle of Islay? Yeah.
Easy to remember.
Right. Yeah. Thanks for that. Understand why Nick Offerman likes it so much. It's easy to remember the origins of it. Isle of Islay.
Yeah. So are we going to, this happens to be Brian's favorite Scotch.
Yes, it's the first scotch I ever really had, and I think it's fantastic.
That's really impressive because I think the first Scotch I had a plastic handle.
I think mine was Doers.
And I think somebody may have written Scotch on it, so I'm not really sure what it was.
Just 3
Good
X's.
on you.
Yeah, so let's give it a try here. So we'll start with the 8-year,
8.
right? See what this guy's all about.
As you can see, it's a little lighter.
A little on the light side.
Let me see the-
Let's do the comparison. Yeah. So you can see the color difference.
We all just
there.
holding them up.
Yeah.
Look at what I have.
All right, so
Okay.
dark guy
Cheers.
down.
Oh, dark eye.
Here we go. Boom. So it's
Not as
good.
bad on the front end as you said it was. So-
No, I said it was unique.
Oh, unique.
Yeah.
So
Oh.
this is a very unique
Oh, okay.
flavor.
All right. So Eric's description of it for me earlier was it's really awful on the front end and then it's so smooth on the back.
Yeah.
No, I think it's good.
Uh-huh.
It just has a unique flavor on the front. Really finishes smoother than you would expect, right? So with the Scotch, it's got a little bit of a peatiness to it.
Yeah.
Some people say that reminds them of a Band-Aid, licking a Band-Aid. That's why a lot of people don't like Scotch. I think it's you either like it or you don't. Right?
So Brian, you were telling us a little bit about the island before.
As I understand it, the island is essentially covered with peat moss. And so therefore, any Scotch whiskey made on that island is going to be peaty. And this is a great example of a peaty Scotch.
And that's where you get that Band-Aid
Well,
flavor.
it's a little chewy. Yes.
I don't think they like to call it Band-Aid,
Oh.
but it is. But
I'm
honestly,
sorry.
that's the main reason a lot of people who don't like Scotch will say that that's what it is about it that they don't like. So,
Okay. All right.
all right, moving right along. Here's the 11-year special edition. See what this guy's all about. A little richer.
A little more substance to it.
Yeah.
Yep.
I would say it's starkly different. Like I just expected more refined taste, but I think it's really different.
Smoother
Smoother, absolutely, but
Yeah.
very different.
by like 3 years.
So cool.
Yeah.
You know math.
Yeah. I had to think
So
about it too.
so it's it's different. I think it's very different. I think it's I'm gonna try it with the Guinness.
Oh yeah. Well, I guess I wasn't really considering the fact that it might have some kind of Guinness or sweeter undertones.
I
Maybe.
don't know. I've never had the 11 in this Offerman. Is it Offerman?
Yeah, the
Yeah,
Offerman
I've
edition.
never
Yeah.
had that before. It's very good.
It goes
It's nice.
perfectly well with the Guinness, which is not surprising.
Right. Well, this has been good. I think we've done a really good job faking our way through knowing anything about Scotch. right?
I'm not pretending. I know that Brian does know. You've done a wonderful job at faking. your
I
way.
faked my way through it.
I learned today how to say the word island.
I thought you did
In
great.
advance of this, I
Yeah.
thought I better learn how to say that word.
See,
Thanks for preparing for
Yes,
this today.
yes.
yeah, we
That was
appreciate
good.
it tremendously.
All right, well, here we go. So we're gonna just continue sipping this as we discuss our claims issues today. And I think what we're gonna do is go through sort of an overview of the process itself. You know, you've obviously been involved in it on the one side, you're involved in it all the time. You made a comment earlier, Brian, where, you know, a lot of firm owners, a lot of times, whatever litigation they're involved in is the only thing that's going on. That's the only one they'll ever see. We see it, you know, from our side of things on the insurance claim side. Brian sees it on the legal side. So we'll just go around and get everybody's perspective on it. So Jen, where does it start?
So if there was ever a topic I think that deserved whiskey and beer together, it's probably this, right? Because that moment that it happens, that sinking feeling of something went wrong. So whether it's a call from, a project manager, hey, I think something's maybe going off a little bit, or a call from a project owner, I'm not loving what's happening, or, a screaming match in the middle of a project meeting, right? And that happens too. So there are, and then there are the other things, the bodily injury claims, the injuries on site, those are different. What I'm talking about right now is I think I made a mistake, that sinking dread feeling, and someone's accusing you of it. That moment is profound for most people. It's one of those things, they remember where they were, what they were doing when they found out what happened, all the details. So from that moment, it's a matter of whether or not they remembered the classes or the conversations they've had with us saying, hey, remember us? We can help you, call us. And then that call comes in from us or to us. And from there, we try to get them the help that they need. And usually that help comes in the form of an adjuster giving them a call.
Mhm.
Sometimes it's you, Brian, right? You're giving them a call to help them.
That's exactly right. I mean, I think that ultimately, there's a reason why you pay premiums, and that is, hey, if something goes wrong, you need some help, you need some protection. And so you shouldn't ever hesitate to make that call. You shouldn't ever hesitate to say, oh, well, maybe this will just blow over. It's better to get out in front of it than hoping it'll just go away.
Yeah, so a few things I think are maybe a common misconception. Hopefully our clients are sensitive to it, but maybe not everybody is. The call to us, that initial phone call saying, hey, I think something's brewing, we might have an issue on our hands. Professional liability is not like any other type of insurance. It's not like an auto policy where, as soon as you call the insurance agent, it's as if you're putting the claim in, right? So we have a little bit more latitude there with professional liability to have that conversation. Saying, well, let's see what's going on. Let's talk about this, see if, maybe the right answer is to wait a day or two and see, if you're on your way to a meeting, and see how that plays out. But more often than not, we get that call well before this has become a full-blown claim. And so what does that mean? So a claim is that formal, there's allegations against you, they're alleging a wrongful act, or naming you. So whether that's, in the form of a summons, or it's in the form of just, an email or a phone call saying you screwed something up, and you're going to fix it, or you're going to pay for it, that's a claim. So whatever form that comes in, but there's a lot that happens before that sometimes, where you might be aware, like you mentioned, you kind of get that sinking feeling like, oh man, I think I screwed something up here. What do you do in that situation? And we have a solution for that too. And it's pre-claims assistance, it's circumstance reporting, and you call us and let us know what's going on, and we can start that file and get an attorney involved to kind of help you through the process early on.
And I think that the difference between the auto policy that you're mentioning is, you don't say to yourself, gee, I think I'm going to get in an accident tomorrow. and I'm gonna call my carrier and say, hey, what should I do? With a professional liability policy for the AE people, you can say, hey, I got a funny feeling about this thing. Something's going a little screwy.
Right.
Could be a contractor making a number of requests for change orders, that kind of thing.
Right.
Could be an owner saying, hey, this doesn't feel right. What's going on? You can reach out to the carrier through ProMart, through Jenn and Eric, and say, hey, what's cooking here? What do you think? Do I need some help? And sometimes the right thing is, sure, yeah, get some help.
And the big thing is that it doesn't negatively impact the policyholder the way that it, I think a lot of people think it will, like it's going to be an incident. It's going to be a black mark on their claims history. When we're talking about pre-claims assistance, that circumstance reporting, insurance companies really, they kind of like to see a laundry list of circumstances that don't really go anywhere, because that tells them that you're actively involved in your claims management process. And so that's actually viewed as a good thing. So it's kind of a benefit on both sides of it.
And I also think it should help you sleep better at night.
Right.
If you make the call and they say, okay, let's get some help, we get somebody in there, maybe me or somebody like me comes in, says, hey, you know what? I think you're okay on this.
Right.
Look, we can't ever say, never get sued, but that's not what you want. You want, okay, what's going on here? Do I have something to worry about? And you can do an analysis. And a lot of times the analysis is, you're okay. Don't worry about it. Thanks for calling. Let me know if something changes, and off you go.
So even in those moments, though, when it's not just, hey, you're okay, it's no big deal, let's just move on. Even in those moments, I think it's really important for our clients to understand that they're not alone. Our response may be a little bit more, it's not clinical at all, but calm. Your response, Brian, is likely to be more calm. And here are the facts. Let's do this. We're empathizing, but we're trying not to add to that drama. Because in that moment, this is hard for you. We get it. I get it. I personally get it. You live, breathe, eat, sleep, all of the details of that claim and what went wrong, what you did wrong, or potentially did wrong, or could have done wrong, or maybe did wrong, or somebody saw as wrong. You live through that and you know it like the back of your hand, right? So we're empathizing with you, but we want to move you through this process with the clearest heads that we can. And it's important to recognize that we are on your side. So if you call us and you give us that information, we're on it. We're all over it. We're trying to give you a sense of timing. Here's when you should hear from somebody. Here's what you should expect. These are the kinds of conversations you're likely going to have. Don't say this. Don't do that. Let's get Brian involved before you give over the subpoenaed documents, for instance, right? Let's get Brian involved before you have that client meeting and you say something maybe you don't want to say, and understanding where that is. So part of it is understanding where we're coming from. Part of it's the relationship that we have and enjoy with our clients, and you enjoy, Brian, with your clients, that trust that we're going to do the best for you that we can, that we're here for you. But a part of this too, I think, is from counsel side, from our side, what we can always do better with. And I try to tell staff this too. You're working on something. If you don't tell the client you're working on it, they don't know. And they think they're just being left out in limbo. For them, like you said, and you mentioned before, Eric, it's the only thing that they have going on. So giving them a sense of timeline. So let's say this pre-claim, because we're talking about pre-claim right now, right? The other advantage to this, we've talked about it in other seminars and other podcast, is putting a pin in the policy to, that will respond should something actually come out.
Doesn't erode your limits.
Doesn't erode your limits.
Not
right.
subject to your deductible.
Right.
A lot of benefits to
a lot of
invoking that
benefits.
pre-claims
Yeah.
assistance.
But when it moves into that claim place, when someone says, no, you know what, I decided it is your fault and I want you to redesign, I want you to pay for, I want you to do whatever. It's moved into that claim place. Timelines can be all over the place, right? So how long is the longest claim you've seen? Go on.
I once handled a claim that had to do with the design and construction of the above ground section of the Buffalo subway line. And I think that lawsuit was commenced. I think I was in high school when it was commenced. and the case didn't get resolved.
That's a long time ago.
Before, that's a long time ago. That case.
Don't throw
didn't
stones, Eric.
That case, I think it took 20 or 25
Wow,
years
yeah.
to resolve.
Yeah.
And for any variety of reasons, even together, it didn't make sense to last it that long, but it did. And but on the other hand, sometimes claims can be resolved early.
Mhm.
And there's a great deal of benefit to that because A, it gets you off your plate. And B, look, if an underwriter is looking at your premiums or to write a premium and they see that whatever the claim was, you didn't pay suitor a lot of money for it, that helps. So there's sometimes claims get resolved very quickly. It really depends on the personalities involved and the types of claims that are involved.
The openness from all parties to negotiate or to get it settled, to get it moved. I've seen folks just be stubborn, just to be stubborn. People dragged in as, third party, right? And they end up moving and moving and moving. Can we talk for a second about the tolling of a claim where, someone might be just a tangential part, right? So someone gets that subpoena request, for instance, and thinks, I don't have anything to do with this. What should they do when they get that subpoena request for documents? Should they be on alert? Should it be something?
I think that if you get a subpoena, if someone asks you for documents related to one of your projects, I think you should notify Jenn and Eric, and they will notify the carrier. And likely the carrier will retain an attorney on your behalf so that whatever you produce is what needs to be produced, but nothing more. And if you're asked to give a deposition, you'll have an attorney who helps you through that process.
Right.
And that way, even if there is no risk, at least you're in good hands.
Right.
At least you won't inadvertently create some problem that otherwise wouldn't exist. So that's how, if you get a subpoena, you're not in the lawsuit, you're not a party to the lawsuit, but you get a subpoena, A, you have to respond to it, but B, you should probably ask for help.
So having that help there, does that, as part of the process and getting that help when someone's asked for documents, does that change their document retention? Does that change how they should approach the project files, communications?
Absolutely right. So fundamentally, I think a firm should have a document retention policy and abide by it. And by that, I mean, if your policy is at the end of 10 years, which is longer than you have to, but if at the end of 10 years, your policy is you're going to destroy the file, return originals to whomever is entitled to them, but then destroy the file, make sure you do it, because you don't want to have a situation where, well, gee, the only file you destroyed was the file where you might have a claim against you.
Right,
So
right.
That's a
either
bad look.
it doesn't look good. So if you have a policy, well, if you don't have a policy, get one. If you have one, abide by it. And then as soon as you get a subpoena, then you must secure those project documents, emails, telephone messages, drawing, everything, electronic, everything. I think the best thing is to just put them on an external hard drive. Then no matter what happens to your system, you still have them, because you don't want to destroy the documents after you've been put on that those documents are being sought. So put them, secure them away, keep them until that lawsuit gets resolved. Even if you're not in the lawsuit, just hold on to them.
So we've seen before, I know from our side, we've seen where someone has been subpoenaed for documents or deposed for their position on something. And then many years go by and they're brought into the claim. And, they're yelling about statute of limitations, this is over, but a claim and that information has been sought, right? So
here's the difference. If the owner sues the design professional, that firm that has agreed to provide, all aspects of design, and then that firm has in turn hired a consultant, the statute of limitations between the owner and that firm, that primary firm, is 3 years from the date services were last provided. Now, somewhere down the road, 5 or 6 years later, after the lawsuit is commenced, that design firm says, hey, you know what? We thought that was our scope of work. Turns out it wasn't. Turns out our consultant is the responsible party. So now it's called third party. We're going to commence a third party action against that consultant. Well, the statute of limitations for that third party action doesn't even start until the first action's over.
Mhm.
So in essence, when that third party action is commenced, it's oftentimes even before the statute has started to run. So you could get dragged in years later and still have exposure through the prime architect.
So the key there is to make sure that we get involved so that you can get the kind of expert advice that, we can provide, the adjuster can provide, you can provide on how to secure those documents in the event that they're needed later.
So we just had this happen yesterday. We had a firm in Pennsylvania call us because they were presented with a subpoena for their project file and everything else. And when we got it, it came to us saying, we don't think there's anything going on here, but, we received this, so we're just letting you know. Okay, that's fine. So we convince them, we say, we should put this into the carrier, invoke some pre-claims assistance, get you on the horn with, one of the carrier attorneys. And that's what'll happen before it eventually goes to Brian. Usually is one of the claims adjusters from the insurance company will review the file, see what's going on, contact the policyholder, and discuss the situation. If it's something that they need to retain local counsel for, that's when Brian gets involved with it. Sometimes it can be resolved just at the carrier level, with one of their representatives giving some good advice on, here's the documents that you should send over, here's what you shouldn't send over. And ultimately that policyholder came back to us and said, wow, this was great. I was really appreciative that we had somebody on our side who was kind of guiding us through this process. Obviously they had never been through that before. So that was really beneficial for them. But the other thing too, and I think you alluded to it before, let's say 5 years down the road, this does become something that this firm is dragged into as a party to the claim. Well, now, because we reported it this year for this policy term, when the subpoena was received, we've got a pre-claim, and that puts a pin in the policy. And you mentioned that before. And the benefit to doing that is you may change your coverage down the line. You may increase your deductible down the line. Firms grow. Hopefully all firms are growing and getting larger. When that happens, inevitably deductibles get bigger. And we put that pin in the policy from, when we first received notice of this. And that's the policy that's going to respond to it 5 years down the line, if and when this does become a claim. So that's a huge benefit also.
Sure. And contractually, you may have an obligation to maintain certain limits that aren't eroded by claims and claims defenses, which would also erode that limit. You may have a, contractual breach if you have claims that are eroding limits, even just by defense costs, and even an obligation to notify a client when that happens, right? And that notification may go on for several years. So, having somebody on your side that can walk you through those things, huge benefit. Pre-claim subpoenas, requests for statements, information, document files, all those things, treat them like they are precious property. Speak to counsel, get somebody on your side to do it. Absolutely. So now it's turned into a full-blown claim, and clients lose sleep, right? And they're anxious, they're reliving the moments, they're going through everything that happened. On occasion, we'll see somebody who is very defensive about it. I didn't do anything wrong, and this is BS, and I don't want to do it. But that's not usually the case, right? We're talking about.
A lot of times, let's be fair. Sometimes they are a little bit BS, right? I mean,
sometimes they are, but
sure.
I'm saying that the folks that we work with are so thoughtful, right? That they're looking for what could have gone wrong because they're problem solvers, right? So this is anxiety inducing, right? This is. It's a problem that needs to be solved as quickly as possible. And, part of that thoughtfulness, please, include us, let us help you through that. So now we get to the claims process, and it's going to include a lot of, paperwork and, submission of paperwork and deadlines and due dates and things that are going to be like way outside of the the mind spread of someone who's never been involved in that kind of thing. What do they need to know about those initial processes? Anything, or just I'm handling it, let me
Well,
do it?
they need to know this, that anytime they have a question and they're not sure about something, they should just call or email or whatever. Just ask. Because, I'll admit that there are times when, hey, I sort of forgot about that case. It's been sitting there for a while, but that doesn't mean the client hasn't forgotten about it. So, hey, just drop a line and say, hey, anything new, what's going on, that kind of thing. But the process, the first step is, what does your contract say about how a dispute will be resolved? And by the way, you do have a contract, right? You need a contract.
So it's funny, and I'm just going to jump in real quick. I was going to ask you before you ask that question, what's the first thing you ask for when you're assigned to a case?
Oh, yeah.
Right.
Let me see the contract.
Yeah.
Let me see the contract. And we tell everybody the same thing when they're reporting a claim. Make sure you have your contract ready because they're going to ask for it. And sadly, a lot of times we hear, well, there was really no contract for this. It was a verbal thing.
Or it's a letter, or they signed it.
Yeah.
So nevertheless, so within the contract, there should be a choice of how the dispute is going to be resolved. Is it going to be resolved through arbitration, or is it going to be resolved through the court system? Litigation, arbitration, there'll be maybe 3 arbitrators. They should be people well-versed in the construction/design industry who will decide the case. And there is generally rather limited tools of discovery, i.e. you may or may not have depositions. If you have them, they may be limited. You probably have an exchange of documents, but then you'll have an arbitration, and 3 people, 3 could be lawyers, could be design professionals, a mix, will decide the case. And there'll be very, very limited avenues of appeal from an arbitration. On the other hand, if you have a court, you get sued, you get a lawsuit, then there will definitely be an exchange of documents, and there will definitely be depositions of all necessary witnesses, both parties and non-parties. There may be motions, which are requests by one party or the other to say to the court, hey, we don't think this is valid, or we don't think any of it's valid, or we think some part of it is valid. We want the court to throw some of it out. Ultimately, either the case will settle, and that could happen at any time throughout the duration of the case, or there'll be a trial. And at that point, the people who decide the case are either the judge or a jury. And then after that verdict, there's an opportunity for an appeal. Those are the 2 types of resolving cases, arbitration or through the court system. If you go through the court system, your lawyer will likely say, give me your project file. And the lawyer will likely provide it to the other side, and in turn, get the other side's project file. At the same time, if there are non-parties to the lawsuit who may have relevant information, they'll also seek the project file of all those non-parties. This process could take 6-9 months, just in the regular course of how lawyers do business. Then the next step is depositions. And again, depending on how many parties there are in the lawsuit, if there are 5 parties in the lawsuit, it takes a while to get all 5 lawyers to agree on dates and all the clients to agree on dates. And that process of depositions could take a year, it could take 18 months, it could take 2 years, because we have other cases too. So that whole process, it would not surprise me in the least, and we're talking about a substantial case, that between the time the lawsuit is commenced and the end of depositions will stretch anywhere from 2 to 3 years. And then we'll start moving towards a resolution. That's the timetable.
Yeah, so it's significant, right? And for some people, the thought, right? I know for me, it was very nerve-wracking, and you want it done, you want it through, you just want to get past it. So I think it's important for people to understand that the timeline could be significant, and depending on delays, it's not that you are forgotten. It's not that it's not moving along. We just went through COVID. We went through a backup in the court system. We went through, all kinds of things that pushed some of these things back even further. So it is a process that takes time. But I do want to touch on just quickly something that was, very, very difficult to get through, was the deposition proceeding. Now, I have never had to testify in court, but I have been through a deposition. I imagine that it's, the same, if not more dramatic, and very difficult to get through. And I spoke with you, several times prior to that. And, one of the first things that happened when I entered into this awful little engagement called, being sued, was Brian said, let me take it. Let me take this off of you. I thought that was really important to hear. I mean, I wasn't going to, right? It was going to be on me, but it was important to hear somebody else was on my side. It was somebody else that was going to be there. The other really important thing to do was just remember that the truth is the truth, and just to say the truth. This is not your place to grandstand. This is not your place to prove your point. This is your place to just answer those questions. The way you get turned around, even if you're not lying, right? Even if you are telling the truth, but if you're using it as a platform to kind of broadcast your truth, quote unquote, you can get slipped up, turned around, moved around. So remembering to just be truthful, answer simply.
I can't remember a case where after my client testified, the other side said, all right, we quit. You're right. It doesn't happen.
Right.
It doesn't happen. Your job in a deposition is to be truthful, direct. The other side is entitled to an answer to every question they ask you. They aren't necessarily entitled to the answer of a question they don't ask you. So if you can answer in one word as opposed to five, great. 5 words as opposed to 10, great. However you have to do to answer it as simply and directly as you can. And your point is a good one. Grandstanding does not help. It does not help. We know that you, as the design professional, know more about designing buildings than the lawyer does. That's okay. There'll be plenty of time to establish that in front of a jury in a way a jury will appreciate. But sort of rubbing the lawyer's nose in it it's not going to help.
And don't educate the other side.
Don't educate.
Right? Don't give them more information than they already had at their disposal. If you say something and it triggers something else, that's an issue. I'm also really big on body language. So watching the body language of the attorney who was deposing me at the time was fascinating. Luckily for me, the tricks didn't work, but they were intimidating. So it can be very intimidating. And no matter what kind of professional camaraderie seems to be happening in the room, or how you feel like you're on the outside there, you're not, right? Just get through it, be simple, be straightforward, and answer truthfully, simply, no grandstanding. Keep it simple. Don't give them more to work with.
Yeah, it's a difficult process. I don't envy anybody to go through it. So it can be hard. And I like to think that the lawyer's job is to ensure that the witness puts their best foot forward and knows there's someone there that is providing them assistance. And off we go.
Mm-hmm. Absolutely.
So let's talk about the next step then.
Yeah.
Right. So we get through all of that difficult process and, the depositions and everything else. And we get to a situation where maybe there's an opportunity to settle. Right. And what I hear all the time is, why would I settle? I didn't do anything wrong.
Right.
We went through this the other day.
Yeah.
Why would I settle? I didn't do anything wrong. Well, okay. Yeah, maybe you didn't, but sometimes settling is the right thing to do. And why is that? Why would we advocate for that? Why would we tell a client this might be the best course of action for you?
Before Brian answers that question, because I know he's going to answer it brilliantly, I do want to say that in the professional liability world, your reputation is at stake, right? So they give you that ability to decline to settle a case just for the sake,
and
just
we
for
will
the sake of
support that
settling.
decision too.
And I have seen cases, not in the professional realm, but in other lines of business where, it's either we give this guy $20,000 to go away, or we go through a trial and pay out X amount of dollars, and it's all coming out of the insurance company's pocket. And if it's an auto claim, they don't care about your thoughts, feelings, or reputation, right? They care about how much money is coming out of their pocket.
Mhm.
Reputationally, though, for a professional, it's a little bit different. So from the professional liability standpoint, there is some latitude on making a decision there, but I'll let you answer why it's good to negotiate that settlement.
Well, I think that in addition to, did I do anything wrong? There are other considerations, and they aren't necessarily more important, but they are considerations. There are different considerations within the context of the same lawsuit. At the beginning, you might say, hey, look, there's 4 parties here. There's going to be considerable depositions, considerable discovery. I can get you out of this case and save money off your deductible if we just bite the bullet and do it now. So the considerations are, all right, you might save a little money off what you'll ultimately have to pay. You'll get it off your plate. Please don't underestimate
Soft costs.
the toll of having a claim go on you and your people. It takes time. They have to devote their time to that, and that's worth something.
Mm-hmm.
But you should realize, though, that when a lawyer is talking to you about that, they want to just educate you. They're not necessarily trying to get you to do one thing or another. They want to make sure, the lawyer wants to make sure that you have all the considerations to make a knowledgeable decision. And then whatever you do, you do. Off we go. I mean, you say, we're going to fight it. Love it. That's what I do.
Right.
I love it,
Right.
But you may say, hey, you know what? I don't think anything wrong. So what do you think? I think, hey, if we get out of this for this number, no insurance carrier is going to say, wow, he really screwed up. He's going to say, good for him. He made a smart business move. It's just in our world, a nuisance lawsuit, and he's moving on. And there's benefits to that.
Mm-hmm.
So please don't think that because your lawyer is explaining these options to you, the lawyer doesn't want to fight your fight for you. He just wants to make you know what are the considerations before you make up your mind.
Right.
And depending upon your dispute resolution methods too, right? If it's mediation and then arbitration, for instance, there is certainly no guarantee that you'll get the result that you want. Even in litigation, and we see oftentimes like this contractual waiver of a jury trial, right? So you don't know what kind of decision you're going to get or whether it's going to go your way. Is there an advantage in, and I'm asking because I don't know, is there an advantage in mediation over a decision by litigation in publication, right? Like how easy is it to find a decision that was made by mediation versus a decision that was made by litigation? Could that be negatively impactful upon a design firm that was maybe, wrongly, contributed in a litigation decision?
So mediations are agreements. They are agreements among the parties. The mediator has only the power of persuasion. The mediator cannot compel any party to do anything. The mediator depends on the good faith of the parties to come together. And the mediator's job is, I would say, it's like a Venn diagram. He just wants those 2 circles to touch so that both sides can either be really happy or can be really unhappy. He doesn't care. The mediator just wants them to go away with a settled case. Most of the time, when there's a settlement through mediation, it's pursuant to a settlement agreement, which very often includes a confidentiality clause. There are no reporters on mediation decisions. Your carrier will know what it got paid. The other side will know what got paid. The settlement agreement is, I can't think of a time where a settlement agreement was filed with the court. The court doesn't care. They just want to see the one document called a stipulation of discontinuance. When that is filed, the judge says, oh, good, one less case for me to deal
It's
with.
off my calendar.
Off my
Done.
calendar.
Yeah.
So mediation can be, you can mediate a case at any time. Some contracts, oftentimes contracts require mediation before the lawsuit is commenced.
Mhm.
But even in those situations, it doesn't mean you can't mediate it again and again and again. Either informally, just through the lawyers talking, or through the judge's chambers talking, hey, can we do something with this? Or formal mediation sessions with an independent mediator who will try, shuttle back and forth, try and get people to come to an agreement, grudgingly come to an agreement and shake hands and walk away. So those are the only people that will ever know how it came out.
Yeah.
On the other hand, if you try a case
Yeah.
and some newspaper reporter thinks it's an interesting case and there's a verdict, could be in the newspaper.
Right.
And it's definitely in the court system.
Right. So it's searchable. It's
Absolutely.
findable. It's included,
Yeah.
those of you out there who have agency contracts, for instance, right? If they're doing any background checking and so on, may find those. So there are advantages to that mediation and getting it settled.
That's why a lot of times we see settlements that have the no admission of liability
Absolutely.
included in the settlement, right? It's
Right.
just for that reason.
Right.
So that
Mhm.
if
Sure.
it does come up later on, that's on record that, we're not saying we did anything wrong.
Absolutely.
We're settling this nuisance claim to make it go away.
Right,
Mhm.
right.
Yeah, and depending upon your carrier, there may be significant deductible reductions there, right? So as Brian mentioned before, don't shoot the messenger. You mentioned,
Yeah, we do like mediation.
we do like
Yeah,
mediation.
we'll give you some credits for that.
Yeah, we'll give you credits. They've been narrowing that though. So check your policy. So some carriers are narrowing it to with one year, within 1 year of the, of the allegation being brought or the claim being
And they're doing
brought.
some different things too, because, I think as much as we love mediation and we push for it and we say it's such a great thing, how often are our claims actually settled through mediation? I think it's a relatively low percentage, maybe.
Especially within that first year. I mean, especially, and now.
Well, and they
uh,
get settled through other means too. It might not get settled through a mediation proceeding. It might just be settled separately. And so there should also be a deductible credit for that. And so some carriers are responding to that
Yes.
as well.
I've
Agreed.
found that some carriers have a rather broad definition of mediation to include perhaps a settlement brokered by the judge.
Right.
They'll say, oh, we'll call it a mediation, because it really is. It's just
Right.
another form of mediation. And again, mediation is just, here's somebody who's not affiliated with any of the parties, trying to get the parties to come to an agreement to resolve the lawsuit.
Mhm.
That's, in my mind, that's a mediation.
Right.
So it's all.
So whether it's a formal process or, less formal than that, but, we always talk about when we give seminars and things like that, we say that we live in this theoretical world of, the what ifs and, make sure your contract is sound and all those things. Well, the claim is when we start looking at the contract again, and when we hope to God that we've negotiated,
Fair
good
terms and conditions.
of the
Yeah.
contract.
Right.
And that's one of the areas is how are we going to dispute this claim? How
Yeah.
are we going to approach this issue that we have? Hopefully we haven't agreed to an arbitration, because I think we've beat that horse to death, and we know that we don't really like how that process goes down. But there are things that you can do contractually to kind of step up to litigation, right? You can contractually mandate discussions internally. You can contractually mandate project manager meetings to hopefully resolve a claim prior to any binding dispute resolution method.
Mhm.
And so we like to see those things, and that's when this comes to fruition.
Yeah, I think we have another podcast on dispute resolution methods.
Was I alluding to that at all?
Oh,
Is
were
this
you?
cross
Was that
marketing a little bit?
cross marketing? There it is.
I don't think I was doing that on purpose. Good recognition, though.
Yeah, you're welcome.
All right. Well, this has been good. Anything
Yeah.
else? Anything else we want to touch on?
I
before we
don't
sign
know.
off for the day and continue our Lagavulin?
Yeah, no, I'm just here for the scotch.
So is Brian.
Absolutely. And I would say that there's a little known sibling to the 8 and the 11. There's a Lagavulin 16. It's not so bad either.
It's pretty good.
So is the
Pretty good.
determination that it's the 16 just is that much better?
Yeah, it's pretty good.
It is.
I
pretty
would
good.
say, I mean, I don't know what the price differences are between all the different levels, but I mean, if you're throwing down for one, may as well get the good one,
I
right?
think we're rolling like a solid $30 to $35 per level.
I think that
Is
if,
that what it is?
Yeah, I think it is.
as the holiday season approaches and you're asked, what would you like? I think you would say 16.
Give me the 16.
Yeah.
Give me the 16.
From Brian's perspective, think about all the cases I've settled and all the great things I've done. Give me the 16.
You know what? If
Yeah.
from my world though, because of where I live, if I say 16, I'm probably gonna end up with Jenny Pounders. So just gonna have to.
Also, not a bad gift.
Are you nuts?
I don't know, man. I
I
like
sense-
what
I
I like.
sense
What I
some-
like.
I sense some foreshadowing here.
All
I
right.
like what I like, Jen.
Yeah.
All
I
right,
got
well,
it. I got
hey,
it.
This has been great. Thank you, Brian.
Yeah.
for
Thank you,
joining us.
Brian, for
Thanks
showing
for the
up.
invitation. It
I
was a
feel-
lot of fun. I
I
appreciate
feel
it.
like you legitimatized our our
That's
whole
the Lagavulin
existence
talking.
here.
Yeah, I agree. I mean, usually it's just us being idiots. Brian makes everything a little
Happy
bit
to
better,
help out.
so.
Happy to help us be
So
idiots.
thanks for
Awesome.
thanks for joining us for Whiskey Tips.
Yeah.
More to come. This has been a lot of fun, and we'll see you next time. Thank you.
Thanks so much. Bye, guys.